My name is Donald Brown. I'm a partner attorney with the law firm of Douglas, Haun Heidemann with offices in Bolivar and Springfield, Missouri.
My name is Richard Finneran. I'm an assistant U.S. attorney in the Eastern District of Missouri, and I'm also an adjunct professor at Washington University School of Law, where I teach appellate advocacy and coach the National Moot Court team.
My name is E.E. Keenan, and my partner Sonal Bhatia and I have a practice here in Kansas City representing employees in disputes with their employers.
The first one I ever worked on is probably still my favorite one, and it was the Etheridge versus Tier 1 bank case. Essentially, that was a real estate case where a deed of trust was signed only by one spouse, and they were married at the time that they took out their home loan. And the case law generally is that a husband and wife must both sign that deed of trust in order to validly convey the property to the bank for if they want to foreclose on it, basically. And so, because only the husband had signed the deed of trust, we had to argue that the deed of trust was no good and that the wife was not liable to the bank on the loan and they couldn't foreclose on her house. And the Southern District ultimately reversed the trial court and said the bank could have their lien on the property after we initially drafted the brief. And so my job at that point, and I'm just fresh out of law school at this point, so then I have to apply for the Supreme Court to take it. And lo and behold, they did. I don't know how many people have had their first application to the Supreme Court accepted, but they did accept it, and we ended up having a chance to rebrief it and re-argue it. And they came out with a great opinion that said that we were right, and they could not have the deed of trust. And it involved a lot of equitable law and equitable remedies, and I think even today a lot of attorneys look to it as kind of a equitable primer for the state of Missouri Supreme Court.
I think the case that I'm actually the most proud of is one that I lost. It was an appeal case in front of the 8th Circuit Court of Appeals where we'd received a bad judgment from our district court, the dismissal of an indictment, and I was asked to come on to help with the appeal. And even though we were unsuccessful ultimately in getting the indictment reinstated, we were successful in convincing the 8th Circuit to adopt several different rules of law that I think benefited us in that case and would benefit us in future cases. So that's one of the really interesting things about appellate work, is that, you know, it's not just about that case, it's about the next case. And that was a case that even though we were not successful with, we made good law that was going to aid us in future cases.
I think sometimes the most important cases are the cases where there's a matter of principle at issue, and maybe there's not a huge amount of money at issue or something like that, but there's a very important principle to be heard in the appellate court that can send a message statewide and maybe even beyond about how individuals, governments, companies should be acting and conducting their affairs. The case that sticks out in my mind in that vein is an appeal called Sheridan versus Division of Employment Security that was heard in 2014 by the Court of Appeals for the Western District. And it was appeal from an unemployment benefits decision. The amount at issue was probably no more than $2,000 or so, but the principle at issue was really, really important. And that was that my client, who I had represented in an unemployment benefits appeal, had been denied unemployment for several weeks on the grounds that she was unable to work because she had just given birth to a baby. My client was ready to return to work after having her baby. And so we brought that up to the appellate court, and the appellate court reversed the decision of the state agency, saying that the state agency cannot make a blanket conclusion that a woman is unable to work after she gives birth. And my client's benefits were reinstated. And I thought that was just a huge moral victory for people in the state who want to make their own decisions about when they're able to work and have been put out of work and are entitled to benefits for that. I'm kind of a solitary guy kind of guy. I like to just, it's just with an appeal, it's just you and
your computer and the research, and that's kind of just what I like to do. I love finding an issue and then researching it to find out what all the cases say about it, and then just arguing as best I can for the position that my client has hired us to take.
I think what I love most about appellate work is it gives you the opportunity to sort of zoom out from the particular facts of your case and understand how the case fits into the broader legal framework. Every case, obviously, at the trial level is immensely important to the litigants in the case, the judges and the attorneys who work on it. But once you go up to the appellate level, now the case is going to be important not just to those people, but to future individuals who will come forward, and that case may control the outcome in their case. And having the opportunity to engage in that process and be one of the two adversaries arguing for what you think is the right rule of law is really a thrilling experience and an opportunity to contribute to the broader legal system.
I remember when I was a kid, my dad was home during the day, and he had a very sad look on his face. And I remember asking my mom what was going on with my dad. I was I don't know, maybe 3 or 4 years old. And my mom told me that my dad was unemployed. And as a little kid, I could see already how lack of employment and not being treated fairly in the workplace can devastate a person. And I think that inspired me from an early age to really want to pursue economic justice for people because there's nothing more critical than having a job and being able to provide for yourself and your family.